More is there in the letter. Beyond this, I don't think there is any other issue we need to address. It is an issue of assignment of a case, which is an issue raised in that letter.
So was the this is about lawyers thing?
Yes.
I am so pained at the outcome of this thing. We have all had differences with each other over various matters. They can be judicial, they can be administrative, but never have I ever envisaged that we start going to the press for things like this. It is their complaint against administrative defaults. All right, the administrative head, either he agrees with them or he does not agree with them. But he is not bound to agree with everybody. There are only 4. There are about 23 others or 20 others. I think all 4 should be impeached. And they should be set out. They should be sent home. They've got no place now to give judicial decisions when you start this trade union system over there.
This press conference has left me totally dissatisfied. I completely agree with the approach of the 4 judges, namely that they're concerned about the welfare and well-being of the institution. So are we. And I welcome the fact that they've given a press conference. However, I have a question to ask them. What has led to the present situation? Why is there this divide between the Chief Justice on the one hand and 4 judges on the other hand? I need to know, is there an interference by the executive with the judiciary? That's the only question that really matters to the nation as a whole.
Let me also just take a cue, ma'am, that this move was low on detail but high on symbolism. 4 members of the collegium are out here. They're very clear. They're not calling it a protest, but nonetheless, very high on symbolism. What do you take from that?
I agree with you. It's not about protest. I agree with them, rather. This is not about protest. On the symbolism, I think it's historic. It's phenomenal. It's well done. I congratulate them for having come out and become accountable to the nation, but they have not gone far enough.
Just one last question. Now what falls on the Chief Justice of India? What response is now expected?
The response now expected is communication. The response now expected is consensus between the 5 senior-most judges of the Supreme Court. This must happen.
Well, reactions are coming in from the legal fraternity, but here are the 3 cases that seem to have compelled the 4 judges to speak out. The first one is a petition filed by Advocate Luthra questioning the delay in framing the rules for the appointment of judges to the Supreme Court and High Courts. The case was being heard by a division bench of a Supreme Court, which issued a notice to the government seeking its response. Before the next hearing, the Chief Justice assigned the case to a 3-judge bench led by himself and dismissed the case. The second case relates to the death of Judge B.H. Lawyer, who was presiding over the case on the alleged fake encounter of Sohrabuddin Sheikh in 2005. This morning, the Chief Justice assigned this case to a 2-judge panel. And the third case involves the Medical Council of India and some former judges who were accused of corruption. Justice Chelameshwar recommended that a 5-judge bench hear the case, but this was shot down by the Chief Justice and reminded other judges that he was the master of the roster. The 4 judges have raised the issue of the assignment of cases by the Chief Justice to benches of preference, as they term it in the letter. In the letter they wrote to the Chief Justice, they say, and I quote, "It is too well settled in the jurisprudence of this country that the CJI is only the first among equals, nothing more, nothing less." Now, Rajya Sabha MP and Communist Party leader D. Raja's meeting with Justice Chelameshwar after his press conference has sparked a furor. Raja defending the meeting, saying that he met him as somebody who's known him for long periods of time and also as a parliamentarian. Now, Congress MP Shashi Tharoor, meanwhile, says that politicians should stay out of this crisis and a resolution to the impasse should be found within the confines of the judiciary.
When I came to know about such an extraordinary step taken by him and other judges, I thought I should find out. He said he would meet me and tell me. So I met him. They expect a nation to respond, people to respond. So being a political person representing a political party, I also think on these issues, why it is happening in our country. what is happening to our democracy. These are all concerns for everybody. It is, there is no political party interest.
Article 211 of the Constitution expressly forbids MPs and MLAs from commenting on the conduct of judges, and I've been very careful to couch my answers to you in terms of general principles rather than commenting on the conduct of the judiciary, because that is actually unconstitutional. So to that degree, I think politicians should indeed stay out of this. But it is fair for us to point out that there have been lapses on the part of the central government, and it is fair for us to point out that the judiciary should get its house in order.
Find a resolution within the confines of the judiciary. That's the message there from Congress MP Shashi Tharoor. Meanwhile, finally, an official comment coming in from the Attorney General. Attorney General K.K. Venugopal has reacted to the crisis in the Supreme Court. He says the 4 judges could have avoided the press conference and also added that they should now act in statesmanship and ensure complete harmony. The Attorney General had a meeting with the Chief Justice and also added that all judges should rise to the occasion and wholly neutralize the current divisiveness. Joining us now for our special debate, Abhishek Manu Singhvi, Senior Supreme Court Advocate. Also with us on the program, Kamini Jaiswal, Senior Advocate, Anand Grover, Senior Supreme Court Lawyer. But let me go across to Abhishek Manu Singhvi first. Mr. Singhvi, many thanks for joining us on the program. If I were to bring to your notice the Restatement of Values of Judicial Life 1997, which very categorically states 8 and 9 that a judge shall not enter into a public debate or express his views in public on political matters or on matters that are pending or are likely to arise for judicial determination. 9, a judge is expected to let his judgment speak for himself. He shall not give interviews to the media. And this seems to be the sum and substance of what we've heard now from the Attorney General K.K. Venugopal, stating that this could have been avoided. The press conference itself could have been avoided. But you believe that we're living in extraordinary times, and hence extraordinary times call for extraordinary measures. Mr. Singhvi, your first take.
Well, obviously, you've picked up those last few words from my tweet. I do agree that there is certainly to be kept out of judicial life and the judiciary anything and everything to do with the press, and certainly a press conference is far, far removed. But if there is an extraordinary situation, ultimately the means must perhaps give way to the end. Now here, the question is, does it qualify as an extraordinary situation? Probably, in all probability, it does, because the allegations in the letter, although not specific, touch on 2 issues. One is a particular set of cases regarding which benches were decided, and the other is the memorandum of procedure. Now, there is a further trigger which has already been acknowledged by one of the judges sitting there, Justice Gogoi, that the Loya case was involved. Both these issues, first and foremost, raise important issues of freedom of judiciary. Both these issues, secondly, raise important issues where freedom of the judiciary is in some sense intersecting with the corridors of power. And if it is, then I think it is a cardinal creed for which perhaps even this extreme step, having failed to elicit a remedial response, maybe not justified, not a recurring theme, not justified, but well, it can be explained. Once in a blue moon, you might have to do this, because this requires immediate, urgent redressal. You cannot have benches in disarray on matters allocated subject-wise and then suddenly going to other benches. And I think that is a serious, serious issue impinging on judicial independence, which is the only reason why I'd be prepared to accept the grave exception and anomaly of a press conference.
Okay, so you're willing to accept what you see as a grave anomaly of a press conference because you believe that judicial independence is in question. But let's address the very first issue that you brought up, which is the issue that's been highlighted by the 4 judges in their letter. And that brings to light the question of whether the Chief Justice of India actually has the absolute powers to constitute benches of the court and allocate cases to the benches so constituted. Now, in their letter, and I'm quoting from their letter, they say the Convention of Recognizing the privilege of the Chief Justice to form the roster and assign cases to different members or benches of the court is a convention devised for a disciplined and efficient transaction of business of the court, but not a recognition of any superior authority, legal or factual, of the Chief Justice over his colleagues. What seems to have gone wrong when it comes to the allocation and the constitution of benches, which seems to have clearly irked these 4 judges?
I think shorn of the legalese which you just read, it means simply these simple things. First, nobody disputes that the Chief Justice is and remains the master of the roster. Second, what is being sought is that once a roster is made and allocate subject A and B to Mr. X, subject C and D to Mr. Y, subject E and F to Mr. Z, generally, then more or less that allocation must remain unchanged for individual cases. Thirdly, the more important point this letter is seeking to make, although not in specific terms, is that you cannot have matters of great moment significance to the very life of the nation, especially involving governmental corridors of power issues at the highest levels, allocated straight away to courts starting from relatively I say, junior judges. Now, this is, I think, a valid point, because in the recent past we have had some aberrations in this regard. But the second point is equally valid, that once you have decided on a memorandum of procedure, the simple law, I would say, going back to 93, then 97, and then now the recent National Judicial Commission judgment is, if the government doesn't agree, you jolly well go ahead and implement the memorandum of procedure. There's no question of dependence on the consent of the government, because that is the anathema to the very judgment. And that, I think, is very wrong for the court, as institutionally as a collectivity, to keep waiting and begging and kind of awaiting the government's consent and not.
So you're saying if the government has chosen not to respond, so if you're saying if the government has chosen not to respond in 10 months, then the court should go ahead anyway?
Well, I have written an open letter, published as an article more than 5 months ago. And I said that, assume that after the memorandum of procedure, after the judgment, after all the things that you've said in various judgments, suppose the government delays an appointment, X is being appointed, you delay it, you send it back, you re-refer it back to the collegium. The collegium second time refers it. The government still doesn't appoint. I have written there openly that if you were to call any law secretary or law minister on a contempt notice, all this nonsense would end. And you would not have 469 vacancies in this country which are there today. But why don't you exercise the power which you have? Why don't you exercise the power which you've asserted yourself? Nothing in law anywhere says that in the ultimate analysis, unless and until the memorandum of procedure is finalized and agreed to, the government has a veto power. And last point, very briefly,
fair point, but
you must remember that there is a issue here on both the issues which impinges with the government. And therefore, the subterranean point being here is that where there are very important matters which may affect high persons of authority, then you have to show steely, utmost and complete independence and integrity. And that perhaps is a bit of a question mark, is what the letter is saying.
Okay, so you're saying that the letter questions the independence as well as the integrity. But Mr. Singhvi, where do we go from here? Because as I pointed out to you, what we've heard now from the Attorney General is that the judges, including the Chief Justice of India, should rise to the occasion and wholly neutralize the divisiveness. So the argument seems to be that a resolution to break the current impasse must be found within the judiciary itself. How do we move forward from here? I mean, Justice Chalameshwar said it's going to be business as usual come Monday, but given what we've seen happen today, there is a crisis of confidence with the judiciary. How does one proceed forward? Where does the resolution come from? If you've said for months we've tried to address this issue with the Chief Justice of India and there's been no grievance redressal, there's been no sort of a breakthrough, so to speak, what breakthrough can we now expect? And how does the judiciary go on to function after this development?
Well, a lot of what you are saying is unexceptionable. Certainly all those sentiments are correct. I think, yes, the solution has to come from within. I think, yes, if a solution is not found, this extremely valued and valuable institution will go up in flames, because remember, by several other judgments, you have made collegiality a way of life in this institution. Now, collegiality or collegium require consensus and collectivity, harmony. You cannot have collegiality in even appointing a chaprasi if you have this kind of divisiveness. So certainly this is a very, very important moment, and unless you set your house in order extremely fast, a 469 number of vacancy can become 800 out of 1100 judges of the High Court. But what is the solution? We can all mouth platitudes, we can all mouth big adjectives, we can all give good sermons.
Yes.
The real thing is, and it's actually very simple, I think as the leader of the group, the Chief Justice has to step out and embrace his colleagues. And I don't mean a physical embrace, but the metaphorical equivalent of a physical embrace, and say, look, let bygones be bygones. From now on, we'll follow these broad 4 or 5 principles in as far as benches are concerned and in as far as memorandum is concerned.
Yeah.
Now, if he steps out and there is lack of cooperation by any of the other judges, then the fault shifts to that side. And I think this has to be an act of statesmanship which must transcend every form of ego everywhere, across the board.
Mr. Singhvi, Mr. Singhvi, let me end by asking you, sir, and you know, there are all kinds of... Sure, you believe it's not difficult to solve, but we need to move beyond mouthing sermons and platitudes, as you pointed out. But let me end then by asking you, Mr. Singhvi, you know, there's a lot of narratives that are being spun today on whether this is part of some sort of political conspiracy and so on and so forth. And I don't want to go down that road or indulge in any of that speculation, but I want to ask you, what, to your mind, is the role of political parties in all of this? There's a lot of speculation on the role that the Congress party as an opposition is now likely to play, whether we will see statements coming in from the Congress party and so on and so forth. The government unofficially seems to be suggesting that politicians should be hands off of this matter and let the judiciary sort of arrive at some sort of a resolution. What is the role that we should expect from our parliamentarians and politicians in this matter?
A bit of a wrong and a bit of a right, both in your formulation. At one level, it is true that political parties, political persons, MPs, etc. have no role to play. This has to be ultimately solved within the institution. That alone will be a lasting solution. You cannot have, external interference, because that actually implicates and denigrates the very value which you are trying to preserve, which is independence of judiciary. But at another level, you are wrong. The subject matter of this dispute is what? The subject matter of this dispute, as reflected in the letter which ordinary mortals like us have, we are not privy to the internal facts, is twofold. Both the issues in the letter touch upon issues of independence, which is an intersecting point between the judges and the executive government of the day. Now, in the matter of intersection between the judiciary and the executive government of the day, if you have shown less than steely determination for steely independence, then somewhere, I think, the government has to answer. It's not a very happy situation for a government. The government is indirectly, therefore, being told through the letter that there is a degree there where matters of moment, matters of importance, matters in the corridors of power are being dealt with differently. Now, that is something which, of course, not only at one level impinges very, very, very gravely on independent judiciary, which is part of the basic structure of our constitution, but also raises a big question mark for someone to answer, and that someone to answer can only be the government.
All right, Mr. Singhvi, we'll have to leave it there. Appreciate you joining us here on Cnbc TV 18. Abhishek Manu Singhvi. Let me go across to our other panelists as well. Anand Grover, Senior Supreme Court lawyer. R.V. Ishwar, former judge of the Delhi High Court, with us. Mr. Ishwar, Justice Ishwar, if I could start by asking you, sir, and you know, this matter has sort of split the legal fraternity down the middle as well. We just heard there from Abhishek Manu Singhvi expressing one point of view. Justice Ganguly, who I spoke with earlier, also seemed to echo what we just heard there from Abhishek Manu Singhvi. But Justice Sodhi, for instance, has taken a completely different view. He says that what these 4 judges have done today is bringing a trade unionist approach into the judiciary. He goes as far as to say that they should in fact be impeached. Justice Ishwar, your first comments.
Those are pretty strong words used by Justice Sodhi. I would not like to enter into the controversy as to who is right and who is wrong, or who is to be impeached and who is not to be impeached. But all I can say is that this unfortunate incident has really shaken the judiciary, and it has affected the credibility of the institution called the Supreme Court. Now, this is quite an unprecedented step which the 4 judges have taken. But at the same time, I mean, a collegium is not a corporate boardroom where you are combative. But at the same time, having said that, it is in my opinion, what I hear from the interviews of Justice Chalameshwar and the other 3, what I could gather is the object of the press conference is twofold. One is the judges are clearing up their conscience. They have clearly said that 20 years down the line, we don't want anybody to point fingers at us, saying that we didn't do our duty. Number 2, more importantly, the press conference has the effect of putting more pressure on the CJI, because the judges have said that we have met you several times, we have raised these issues with you, but there seems to be no solution. And therefore, they came to a dead end, and then they had to go to the press. The result obviously is to put pressure on the CJI through the public comments.
So, Judge Ishwar, that is.
So I think
that is my question to you, sir, and that was my question to Abhishek Manu Singhvi as well.
Is good for the institution.
So you believe that the public pressure that they seem
to respond.
You believe that the public pressure will work, sir? Do you believe that the public pressure will work?
Certainly, it will work. Because after all, the Supreme Court is for the public, and the CJI must as rightly pointed out by another panelist, he should show statesmanship, and he should come to the table and discuss it not only with the 4 judges, but there are other 22 judges of the Supreme Court. He should take everybody into confidence and then find a solution internally, because there is, I mean, the judges cannot file cases against each other. Any dispute between them with regard to the roster and all that has to be settled internally only. And nobody can question the fact that the Chief Justice of India is the master of the roster. At the same time, if questions are being raised, after all, who are these 4 honorable judges? They are men of experience, eminence in their own right. They have been Chief Justices of the High Courts, and they have also made rosters. And when they raise a point, and which against the roster, I mean the making of the roster by the Chief Justice of India, the Chief Justice of India has to listen to them, and if there is anything which is arbitrary or which is not desirable, it should be set right, because there is an adage that justice should not only be done, but it should also appear to be done. So once he does that, everything will be clear, and he must go to the discussion table, sort it out with them.
So he must take the lead is what you're also saying. Kamini Jaiswal, I want to come to you because, you know, when we spoke, when the press conference broke this morning, you said that you were not at all surprised that this didn't come as a shock at all to you, though it may have come as a shock to a lot of us. But I want to pick up on the point that we just heard there from Judge Ishwar saying that, you know, the sentiment echoed there by the 4 judges was that, look, 20 years down the line, we don't want to be seen as having sold our soul, and we want to pay our debt to the nation, and hence we've decided to go public with our grievances. But, you know, Indira Jaisingh, for instance, saying that they haven't gone far enough. Kamini Jaiswal, that seems to be the view of one half of the legal fraternity.